there are documents that are required. So for civil proceedings, it involves those cases where the state is not involved directly. For example, mambo na divorce, the state has no reason to come and you because you've refused to divorce another one. Ni nyinyi mpelekane kotini. Family issues, story of custody, vitu kama hizo, right? Land disputes, the state has no reason or has no authority as the sovereign. Criminal cases is where the state is directly involved because you have either committed a crime or omitted something, all right? So that is what we are saying. So, but for civil cases, most of the time, kuna zile documents that you must produce. Maybe there's a title deed you brought somewhere, umeleta marriage certificate, nona, umeleta document, yani, to help the case. All right, whether the defending side or the claimant side. So there are documents that you bring. If you misuse those documents, maybe you release them to the press without the knowledge of the other party, then you will be found in contempt, in an offense of contempt of court. Tumeelewa hadi hapo? Yes, so it is misuse of any document that is given in disclosure. Yeah, ilipeanwa, but it can only happen, there are those three conditions. If, for example, those documents were just done in public, zilikuwa zishasomwa in public, so it is no longer confidential, you see. Number two, if the court gave permission for those documents to be released to the press or to the public, then hapo hakuna kesi. Number three, if the people agree, both parties agree, both to the person who leaked them na mwenye hizo document, kama aliagree, hapo hakuna contempt, you cannot be taken to court. Sawa sawa. So those are the common areas where as a journalist you must take care under common law contempt. Okay? Yes. The second form of contempt of court is what we are calling the strict liability contempt. And this one is very important. I want you to notice and put it into your heads very well. Ensure umeshikanisha hii. Okay, zote ziko important, but ensure that this one you understand. We have what we call the statutory or strict liability contempt. And we start by saying this is covered by the Contempt of Court Act 1981. So hata hizo case laws ni very, very important to understand. Contempt, this is covered by the Contempt of Court Act 1981. And now we start saying what it is. This contempt is committed, or this offense, contempt is offense. This contempt is committed when a publication occurs. This contempt is committed when a publication occurs, when a case is active. This contempt is committed when a publication occurs when a case is active and the publication creates a substantive risk of serious prejudice, and that publication creates a substantial risk of serious prejudice to that case. Creates a substantial risk of serious prejudice to that case. And then we say the primary function of the CCA 1981. CCA is Contempt of Court Act, the one we are talking about here, is to protect the integrity of active court proceedings. Protect the integrity of active court proceedings by prohibiting the media from publishing information, by prohibiting the media from publishing information that will interfere with ongoing legal cases, that will interfere with ongoing legal cases, that will interfere with ongoing legal cases. So we're talking about now what we call the strict liability. The strict liability contempt. Now, when we talk about this, when cases are active in a court, there is usually laws protecting those cases that you as the media people, you should not publish any information that will cause a risk to that case. For example, if it's a murder case, you cannot just go publishing things, because now you'll either be causing serious problems to the prosecuting side. All right, that is what we are talking about. And the primary function of now that act, there's an act, that's which we are talking about, called the Contempt of Court Act of 1981, which now prohibits us as journalists from publishing that information. Now, where does the strict liability come from? And when we talk about strict liability, what does it mean? Let's first of all now separate the two words. When we talk about liability, what do we mean? Ukisikia hiyo jina liability, what does it mean? What comes to your mind? We know liabilities in business. When if you went to a business class, have we been to a business class? No. Hey, Rahab, you haven't. You're shaking your head. You haven't been to a you didn't do it in high school at all. Have you heard liabilities and assets? Assets and liabilities. What does it usually mean? What comes to your head? Ukisikia assets and liabilities in business. Now we're talking about in business. Richard, in business terms, when we talk about assets and liabilities, what do we mean? No, but generally, it's general knowledge, even if you didn't do business in high school. Liability ni? Something reliable. No, it's not. What do you? Yeah.
An asset is something that has specific value attached.
An asset has some value to it. What about a liability?
Liability, in general case, it's something that takes the worth of something.
Takes away the worth of something. All right, you're correct. An asset is that which will not depreciate with time, but a liability will, like a car. Like a car. A car is a liability. Ukibai gari leo, the minute imetoka kwa showroom, ishakuwa liability. Ishaanza ku lose value. Kwa sababu ishaingia kwa barabara, si tires ishaanza kuisha. Yes, you must now start thinking about new tires. Haya, lazima uweke petrol. Hiyo si inakukula mfuko wako. Yes, but something like land is an asset because it appreciates with time. Unaweza grow mimea hapo, you can sell it. Of course, even if you can sell a car, but you're not going to sell it at a higher value than you bought it. Why? Because kuna vitu imeshaenda, mileage ishaisha. All right. Now, when we talk about liability now, when we in terms of now court, right? It means that anything that you are going to do, that contempt that you are going to do, regardless of whether you knew it or not, you would be liable for it. Now we are talking about there's a saying called ignorance not what? Tunasemanga ignorance is not a defense. No, there's that saying in English, ignorance is not bliss. Tunasemanga hivyo. Ignorance is not bliss, meaning that you cannot just say I didn't know. All right? That is what that means. That when you do something that has a strict liability to it, it means that whether you knew it or not, you're going to be liable. You're going to be held liable. And that is the case for this type of content. So as a media person, whether you knew when you were publishing or not, you're going to be liable. All right? And like now, the others zenye tumeongelelea hapo juu is a common law contempt. For example, we have said if you published and said or failure to comply with a court order, you can just say sorry and you are let go. You can make an excuse, yani. But for strict liability, there is no excuse whatsoever. Are we getting the difference? All right. So now let's talk about the strict liability rule. That's our next subtopic, the strict liability rule. The strict liability rule. We say this. Criminal liability usually involves both a mental element, that is what we call mens rea, criminal liability usually involves both a mental element, into brackets what we are calling mens rea, and a physical element, actus rea. So the physical one is called actus rea. And the physical element, or what we are calling actus rea, of the offense. Full stop. And then we say, therefore, for a crime of murder, the prosecution must prove that, therefore, for a crime of murder, the prosecution must prove that the suspect fired the gun. The prosecution must prove that the suspect fired the gun and did so with the intention. The suspect fired the gun and did so with the intention of killing the victim. With the intention of killing the victim or causing serious harm. However, so full stop. However, in some criminal offenses such as road traffic accidents, road traffic accidents, environmental offenses, and contempt of court, road traffic accidents, environmental offenses, and contempt of court, the requirement for a mental element is not necessary. The requirement for a mental element is not necessary. Such offenses are called strict liability offenses. Such offenses are called strict liability offenses. Let's write this before I explain. The strict liability rule under the CCA 1981, the strict liability rule under the CCA 1981 provides that any conduct that interferes with the course of justice, can be treated as contempt of court, even where there is no intention to interfere. even where there is no intention to interfere. Even when there is no intention to interfere. So we've started by having a scenario there. When we are talking about criminal liability, when you have committed a crime, for example, murder, yeah, you've killed someone, you've taken a gun and you shoot someone. So what the judge is gonna be looking at are two things, and I want you to listen very carefully. The judge is gonna be looking at two things. They're gonna be looking at the mental element. When they're looking at the mental element, they are looking at, did you have the intention? What was your intention? And that is what we are calling mens rea, all right? Then they are going to be looking at the act itself. How did you do it? Did you actually kill the person by shooting them, by cutting them? Did you actually kill them? So they're going to be looking at the physical element and the mental element, yeah? So for the crime of murder to be, for there to be a prosecution, they must prove those two things. Unasikianga mtu akishikwa, they must be taken for a mental evaluation to ascertain whether they are okay up here. Were they okay when they did that thing? Such that if they are not okay up here, they had some issues, such as they had the issues of depression, schizophrenia, they had those issues. Ulikuwa na story tu kwa kichwa yako, mbona unacheka? Why are you laughing? What's so funny? Are you relating? Ama you've had someone being, oh, you've had, the story is coming now. Thank you, now I'm helping you understand. So now they are going to be looking at the mental element of this person. Were they okay up here? Is there a reason behind them doing that? So if they ascertain that you had the intention, ulikuwa na mipango ya kuua huyu mtu, then you're going to be judged, you're going to be prosecuted now. There's going to be a prosecution. But sasa kuna zingine, like you hit someone with your car. Someone was crossing the road. You hit them with your car and they die. So then they're just going to be looking at the physical element. They're not going to care whether you had the intention or not, because you have killed. Hiyo ndo makosa umefanya. Yani, regardless of whether you had the intention, wewe umeua. So you cannot say haukujua because makosa ishafanye. So you cannot say that you know. So that is why I'm telling you, under this type of law where there's strict liability, then there's no excuse whatsoever. So it's the same thing. In this case, if you do anything that is going to cause a serious prejudice to the court or interfere with court proceedings, if there is a strict liability rule, then you're going to be found guilty regardless of whether you knew or not, or you had the intention. Not even knew, you had the intention. Ukipublish, maybe ulikuwa unataka kuserve public interest, ama ulikuwa unataka kuonyeshana tu, you just didn't know that you're going to interfere, but you're going to be held liable, all right? That is what we are calling the strict liability rule, all right? So for it to apply, three things must be there. That is what we are talking about now. We say this: for strict liability contempt to be enforced, for strict liability to be enforced, the following elements must be present. The following elements must be present. 1, publication. 2, active proceedings. And 3, what we are calling substantial risk of serious prejudice or impediment. Substantial risk of prejudice or impediment. Substantial risk of prejudice, or what we are calling impediment. Benye tunaisema impediment. So for there to be a case of strict liability, contempt, those three must be present. So let's discuss them further. Let's start with publication. What does it mean? What does publication mean? So let's start with publication. And we say publication includes any speech, writing, or other communication. Publication includes any speech, writing, or other communication in whatever form, which is addressed to the public at large, or any section of the public, Strict liability, therefore, applies to all the usual output of the media. Strict liability, therefore, applies to all the usual output of the media, including newspapers, magazines, TV, plays, concerts, public speeches, radio programs, and the internet. Full stop. Where there is proof of publication, then an author, speaker, can be held liable under contempt law. So here they're going to be looking at, did you publish anything that might interfere with the proceedings of this case? Yeah, so they're going to be looking at any type of publication, and you have said in this case they're going to be looking at, is it a newspaper, is it a Facebook post, because we have mentioned the issue of internet. So they're going to be looking at a media outlet, and then they're going to be looking at, did you publish the information, and you'll be held liable under the contempt law. Then another thing that must be active, number 2, is active proceedings. There must be active proceedings. So hawezi tu shikwa kwa kesi tu yoyote, the case must be active, ongoing. Yeah, lazima ikuwe, when we talk about active, it must be ongoing. Yeah, it is taking place at that time of publication. The moment you published that post, there was an ongoing case. So we say this, for the strict liability to apply, the proceedings must be active, that is, the proceedings must be active, that is, they should be about to start or already ongoing. If the proceedings are not active, there's no danger in publisher being found to be in contempt of court. There is no danger in publisher being found in contempt of court under the CCA. There's no danger in publisher being found to be in contempt of court under the CCA.